Good morning, everybody, and welcome to the 8th in our series of breakfast briefings with me, Kaz Carrington of KLC Employment Law. Today, we're going to be looking at managing persistent intermittent sickness absence. Just some things to shout out first, if I may. Please ask questions as the briefing goes along in the chat. Melanie Whittle, KLC, will be answering those questions where we can as we go along. If we don't get to answer your questions, then email into us and we'll get you an email response back, obviously about matters that we're talking about today. So thanks, Mel, for doing that for us. Technical support today provided by Liv Harris of GoHo. So again, thank you, Liv, for that. So that's about it. Let's move on and look at the topics today. So first of all, we're going to look at diagnosing behaviour. By that I mean it's important to work out where we are in terms of the behaviour the person is exhibiting, and then further diagnose that when we know that actually it is sickness absence that we're looking at. So that's the first matter. Then on to look at those potentially fair reasons for dismissal, because it's crucial. When we start off in a procedure, we have to know where we might potentially end up, because otherwise we might be in the wrong procedure, which will obviously render the dismissal unfair, and we might end up dismissing for the wrong reason. Again, that's going to render the dismissal unfair. We'll look at some case law, because I'll be saying some things to you this morning which you might think, well, why is she saying that? Is that right? What does Kaz Carrington know? It's because the courts have told us how intermittent persistent absence should be categorised and dealt with. So we'll look at a little bit of case law. Policy and procedure, obviously, we can identify as many potentially fair reasons to dismiss somebody as we like, but if we don't have a fair procedure to deal with that, then we may as well sort of hang up the boots and go home, because we're not going to achieve a fair process and a fair dismissal. As I mentioned, once we get into knowing that we're dealing with sickness absence, we then have to look at actually what are we really looking at here? Are we looking at something which is somebody malingering, or are we actually looking at somebody who is really poorly, chronically ill, or actually are we looking at somebody who's just a bit unlucky with the amount of sickness absence they have? They have these intermittent bouts of sickness absence. Fair process and fair dismissal. So all that in 30 minutes, we will do it. So first off, to remind you, because I said, we have to sort of start at the beginning almost to get to the end, because we have to know where we might end up. So just flip you back to the potentially fair reasons of dismissal under Section 98 of the Employment Rights Act. Capability or qualifications, that's in relation to sickness, ill health, that will be chronic ill health, or lack of ability, or a lack of the skill to do the job, or indeed a qualification. So that comes under capability. Conduct, well, we know what that looks like. That's misconduct, cumulative misconduct, or gross misconduct. Redundancy, we'll know what that looks like when the employer no longer has a requirement for employees to undertake work of a particular kind. Statutory bar, is going to be unlawful for that person to continue working in that particular job. And this one, some other substantial reason of a kind such as to justify dismissal. That is the one that we will be focusing on today, because for most parts, you will be, if you have to, and hopefully you won't have to, but if you have to dismiss for that intermittent persistent absence where there's no underlying medical reason or cause, it will be for SOSA, some other substantial reason. So let me direct you to what might be a helpful little diagram. I use this a lot, really, just to illustrate the three potentially fair reasons for dismissal for this particular matter, and also the processes and procedures that we might want to adopt. So can't do, capability, somebody who is chronically ill, who innately hasn't got the skill or aptitude to do a job, it's a can't do. It's not a willful act. And so in this particular situation, we'd be looking at that ill health policy, being able to counsel people, talk to them about how things are going, where we are in the stage of matters like their sick pay, and what our thoughts are in terms of their future employment. Or obviously with capability, it could be a performance matter, in which case we're looking at our poor performance procedure. Our won't do's, our conduct. This is culpable behaviour, isn't it? Misconduct is a willful act. It's not that somebody, I didn't really know I was doing wrong. We decide it's misconduct because we decide that this is, if you like, a positive act. It's something that somebody is doing to disobey our rules. And then on the right-hand side there, you can see there's some other substantial reason. And this is where intermittent persistent absence sits. And I'll explain why in a little moment. It's neutral. Our feelings about somebody who we dismiss for intermittent persistent sickness absence under this potentially fair reason, we'll always be fairly neutral about. We won't be blaming them. We won't be overly sympathetic. We will adopt a neutral, if you like, approach. Now, I'm talking about adopting approaches because, as I've said before in these briefings, when we look back at our documents and when we look back at our meetings and our emails and the conversations we've had with people, that might someday be thrown back at us in an employment tribunal. So we want to make sure that the approach and the tone that we've adopted are completely congruent with the eventual reason that we might have to dismiss somebody for. So that's why I've always labour this point of making sure we adopt the right tone and approach. So just to recap, misconduct is a blameworthy matter. Okay, we're going to give somebody a chance to redeem themselves if it's not gross misconduct, but it's culpable behaviour. Lack of capability through poor performance or ill health is not blameworthy. It's non-culpable, and we support, don't we? If it's for poor performance, we support it. Certainly if it's chronic ill health, we support, and we never blame the person. So why isn't intermittent persistent sickness absence categorised as a lack of capability? Why don't we put it under that umbrella of capability? Because it's sickness absence, it could be absolutely genuine and often is. Well, the reason that we don't do that is because the Court of Appeal have been very clear that the right categorisation of intermittent persistent sickness absence when there's no underlying medical condition causing those disparate absences is some other substantial reason. And they set that out in a very famous case. It was Wilson versus the Post Office. Gary Wilson had a sort of a record of having sickness absences. There was no suggestion that he was malingering. They dismissed him eventually. And when they actually dismissed him, they said it's incapability by reason of unsatisfactory attendance record. Well, they knew what they meant. They knew that he wasn't incapable of doing the job, and he knew that as well. But he brought a claim of unfair dismissal, and the tribunal picked up on this word incapability. And they said, well, if you're saying somebody's incapable, that means you should have used a different procedure. They were obviously chronically ill and unable to do the job. So it has been unfair. The EAT actually reversed that decision, and the Court of Appeal agreed, saying, look, basically, we all know what was meant here. We know this wasn't a situation of chronic ill health causing the intermittent absences. We know this was disparate illnesses. And by the way, so the Court of Appeal, this should be categorised as some other substantial reason. SOSA. It's not blameworthy, but it's not somebody who's incapable of doing the job. And the logic for this approach and this categorisation is if you asked their GP or the person who was responsible for their health, could be their consultant or could be occupational health, and if you said to them, what are the chances of this person who's off with a migraine today, what are the chances of them coming back in on Monday? They would say jolly good, because there's no reason why they shouldn't be able to come in on Monday, unless of course they were chronic migraine sufferers, and that might be different, that might be a disability. But people who have sickness because they've got a bad back or a cold, or again, no suggestion that they're malingering, but there's no reason to think that their health won't improve, which is why we often say they're just unlucky. And some people think that's us being cynical and saying they're just unlucky. We really mean some people are just unlucky. They have a spate of sickness absence, and it's usually something that is short term, and that will improve. Okay, I said that I'd talk about case law, and the first one was the Wilson Post Office. The second one is the Lilac versus Cereal Packaging Limited. This is an EAT case. And the point is here that a lot of the time people will say, well, Cass, if you're not categorising this absence as capability, because you're saying they're not incapable of doing the job, because they might be well tomorrow, well, why isn't it misconduct? Why can't we use that procedure? And part of the reason for that is that, again, the EAT have given advice here in this case, way back when, saying, look, it should not be categorised as a disciplinary matter. We're not saying this is culpable behaviour. It's not blameworthy. It's not a willful act. They also went on to say, the EAT, and this kind of underlines what the Court of Appeals said in Wilson, that where unconnected intermittent periods of absence are concerned, it's impossible to give a reasonable prognosis or projection of the possibility of what will happen in the future. In other words, could be that that person is going to be perfectly okay next week or even the next day. So we have a clear message from the tribunals and the courts that this is categorised as some other substantial reason. Okay, so if you're doing anything else, if you are categorising it as non-culpable conduct, but not conflating that with your misconduct warnings, then that would be okay. I would just counsel that that might be a little bit confusing for maybe some of your line managers, and perhaps better to have a separate procedure altogether. Okay, so where have we got so far? All the absences for sickness, regardless, are to be treated as genuine. Never allow your line managers to insinuate that somebody is swinging the lead, that's an old-fashioned term, but malingering, because unless we have real evidence that somebody is doing that, we must not suggest that. And 95% of the time, they will be genuinely ill. In fact, if we go back to think about the Lilac case, actually every single sickness absence, and there were quite a few, was certificated. So there wasn't a case of them saying that this person was malingering. It was just a case of they were having too much absence from work. The attendance was not good enough. So rather than thinking about this being a capability issue because they can't attend work, it's not that. It's an issue for us, the employer, because their attendance isn't good enough. It doesn't meet our standard. And if you categorise it in that way and think about it in that way, it does help you separate it out from those chronically ill people who are incapable of doing the job. Okay, so one of the prerequisites clearly of knowing that somebody hasn't got an underlying medical condition, because of course if they have, this is going to be something which is very likely to be considered a disability. If it's a chronic condition, there's no doubt of that. But we have to find out, and the best way we can do that is obviously asking the medical professionals, because unless any of you are qualified doctors, we haven't got the ability to diagnose that or to make that suggestion. So we will ask the question very simply, is there any underlying medical condition which is the cause of all these different absences, sickness absences? And more often than not, in fact, actually in the majority of cases, the answer will come back, no, there isn't. Of course, if there is a reason, then we do not categorise this as some other substantial reason. It is not intermittent persistent absence with no underlying medical condition. It is something for which we will have to very likely make reasonable adjustments for, and that will mean adjusting any of our procedures. So, for example, if we adopt a procedure where we look at the amount of absences that people are having in a given time, we might well adjust that. Some employers do that. Some employers actually remove people who are disabled and having intermittent absences completely from that intermittent absence procedure and just deal with the matter as making reasonable adjustments and go on that basis until the adjustments they're making, i.e. the time they're allowing the person to have off, isn't reasonable anymore, at which case they may move to dismiss if they choose. Okay. Just to go on with ERA, as I always do, Employment Rights Act, Section 98.4. We've talked about Section 98.1 to 3, which are the, the reasons, potentially fair reasons for dismissal. Remember, Section 98.4 is the piece in ERA that demands that we not only identify a potentially fair reason, but once we've done that, we all have to make sure that in all the circumstances of a particular case, that this is a sufficient reason to dismiss, given mitigation, given all the matters concerned. And so even if we apply a consistent procedure, which we will have to apply this procedure consistently across our whole workforce or across a team or a whole department, depending on how you're going to work this. But even if we do that, and even if we give warnings, and even if we have gone through that whole process and we've dotted our I's and crossed our T's, the final decision about whether that person will be dismissed, remember, comes down to Section 98.4. In all the circumstances, is it a sufficient reason to dismiss? And remember, the tribunal will be judging your actions on the basis of would any reasonable employer have dismissed in these circumstances. If any reasonable employer would, then it will be fair. If no reasonable employer would, then it will be judged unfair. So we need our fair procedure, but we also need to be aware of that Section 98.4. And often we'll be throwing you back and looking at that and saying all these things, it gets go to practice, whatever it might be. At the end of the day, you'll be judged on Section 98.4 of the Employment Rights Act. But of course, talking about our fair procedure, we would be looking at applying this consistently. Now, you might apply it consistently. You might just have a group of people, say a department, where it is very important that you have absence monitored. I mean, personally, I wouldn't do that. I would do it across the piece, but some organisations do. But let's just say wherever you apply the procedure, you apply it consistently. And that means you have to make sure your line managers are reporting back about sickness, absence, and there is that flow of information between you and them, so everybody knows where they are in terms of the amount of absences that people have had. Because you can imagine if you apply it inconsistently and you sort of take action against a group of people who are just visibly absent, if you like, conspicuous by their absence, as it were, then actually that will be unfair. So we have to make sure we apply this consistently. Now, back to work interviews. I'm sure all of you, most of you, will be doing that. Your managers will be seeing people when they return to work. I mean, in the days of people working in a hybrid model, it might be that you are doing this via video call, but we'll be welcoming people back to work and we'll be making sure that they are fit to work. And part of this, if you like, duty of care is also making sure the individual knows that we're aware that they've been ill, they're now back at work, but we have a note of that. So back to work interviews have been found to be one of the most useful tools, if you like, in improving attendance, because it's felt that people just, that people who might tell a bit of a fib about, well, I really don't want to go, I had a bit of a hangover, so I don't want to go in, they actually, when having to face their manager, would actually I'd just rather go to work than have to possibly tell a bit of a porcupine. So these back to work interviews are very useful tools, but also so are triggers for action. And those triggers are entirely up to you. Employers can decide what that may be. And I'm sure in your organizations, you already have certain things. You might have a situation where you set out in your policy that if somebody is absent for so many times in a given period, that will trigger attention. I don't mean to say they're going to automatically get a warning or anything like that, but it triggers our attention on that person. We'll then looking to see, what are the reasons have been, has there been, a lot of flu about? Is that why, this person's been off? In which case we might actually say, well, actually, the procedure is not appropriate now, but it's a trigger for us to look more closely at the individual. Used to be used quite a lot, now considered to be going out a little bit of fashion, but it depends what type of environment you're in. And certainly in manufacturing, the Bradford factor is used still. And it's just a mathematical equation, actually. It measures the amount of disruption caused by this intermittent persistent absence. And the reason it exaggerates the score, is because the instances of absence are squared and then times by the actual number of days absence. So if you imagine if you're working in manufacturing, you've got production lines. Oh, it could be food manufacturing, could be cars. But if you have somebody who doesn't turn up for a shift, that can be really disruptive. So this measures the disruption caused. So as you can see in that example I've given on that slide, somebody who's just off for, say, 10 days, they might have, I don't know, they might have COVID, they might have a bad cold, they might have flu. The way that the equation works is that, well, they've only been off for one instance. 1 squared is 1 times the amount of days they've been off times 10 is 10 points, very low score. And then you take the fourth example, somebody who is away for exactly the same number of days, but this time they're off 10 instances of 1 day. So 10 is squared, and then times by 10, that gives us 1,000 points. That just shows you how the Bradford factor exaggerates, if you like, the scores, and it shows us the amount of disruption, again, used in a lot of sort of manufacturing environments. So we've thought about section 98.4 of ERA. I've talked about what that demands, looking at the issue in the round and making sure in all the circumstances of the case it's reasonable, it's a sufficient reason to dismiss if we have to, and obviously our fair procedure. And we will be bound by the ACAS Code of Practice on this, because although it is not a blameworthy conduct matter, we are still giving warnings, and those warnings may lead to a dismissal. And so the ACAS Code of Practice will apply. And so in the same way as we would apply the code to any matter of poor performance or misconduct, we would obviously investigate. So if somebody is presenting as having a lot of absences, we would talk to them. We'll find out, is anything going on with this person, any problems at home, all those sorts of things, any disruption of the travel arrangements. Hearings, obviously the right to be accompanied, and obviously information provided to them before those hearings. Warnings given in the same way that we would give warnings for poor performance and misconduct. But remember, the tone is, okay, well, you have reached the point where you've triggered our concern. Your attendance hasn't improved in a given time, and so the decision of this hearing is that you will receive a first written warning for attendance. And let's hope that you can improve your attendance, and we'll be looking at that over a given time, and you must improve your attendance, or it certainly mustn't deteriorate. And by the way, this warning will stay on your file for a given time, so it'll be live for a given time. So exactly the same way as you would give warnings for misconduct or poor performance, capability, but remember, these are non-culpable. However, we still must make sure the individual understands that this might lead to their dismissal, and obviously the right to appeal applies. So our fair dismissal, our fair procedure, and our fair reason for dismissal, some other substantial reason. However, that's not the whole story, because I've been really focusing in on where there is no underlying medical reason for these disparate illnesses and absences. So let's just go back to a similar diagram. It's not the same as the one before. This time we're actually looking at diagnosing the sickness absence reason itself. So even once we know that somebody has got absences, it could be for several reasons, couldn't it? On the left-hand side there, it could be that we have somebody who has an underlying medical condition that's causing these absences, these illnesses, which appear to us lay people to be unconnected, but actually ask any first-year medical student and they'd be able to say, well, that's obviously symptoms of this particular disorder. Remember, capability, very likely to be considered to be a disability as well. Reasonable adjustments will have to be made. It's a can't do, sympathetic approach. It could be, as we've said so far, our SOSA. It could be just unconnected, and it could be genuine. Every illness could be accompanied by assurances from medics that this is genuine. However, very rarely we will see that somebody who is telling us they are ill and who is going to be absent from work because they have an illness, sometimes we find that that isn't true. And examples I could give you would be where people have said, well, I really can't come to work, I've got such a bad back, and they have been seen by their managers, at football matches or rugby matches or Wimbledon tennis finals, those sorts of things. So where we have clear evidence that there is misconduct, malingering, that is a conduct matter, and we would treat that as such. And where somebody is lying to you, and where somebody is technically actually committing fraud, aren't they? They're taking money under false pretenses. That is gross misconduct. Now, you may not dismiss at the end of the day, but it is a gross misconduct matter for you to consider and then to decide, with regard to Section 98(4) era, in all the circumstances, is it reasonable to dismiss? But that certainly would be the way we would diagnose that. So, underlying medical condition identified, okay. Person's probably considered disabled, reasonable adjustments. If dismissal is necessary, it will be for capability. No underlying medical condition identified, warnings to improve attendance. Remember, warnings not to get better. That's absolutely ridiculous. You can't make somebody get better, but you can warn them that they need to improve their attendance. Otherwise, it might lead to further warnings in the procedure and even dismissal. Remember, for some other substantial reason, we never ever insinuate malingering, and you must get that over to your line managers. There's never any suggestion that that person is malingering, because that could lead to a constructive unfair dismissal claim, early doors in the procedure otherwise. No underlying medical condition identified, but there's evidence of malingering. We've got some evidence, some hard evidence. It's gross misconduct. Our disciplinary procedure is then triggered. And if we do dismiss, remember that will be for conduct. Okay, well, that's the end of everything I have to say on our 8th breakfast briefing. Do remember that if you haven't had your question answered by Melanie, that you can email into us at klc@klcemploymentlaw.com, and we will get back to you with an answer. We hope that you've enjoyed this and found it useful. Do remember that we run the Law on Tour, which deals with these sorts of matters, but on a longer and more complex or in-depth basis, should I say. We run these one-day employment law updates. We run them in the spring and we run them in the autumn, and the next one will be in November. So if you're interested in a complete update and also dealing with relevant topics like this one we've discussed this morning, then look out on our website, on our Law on Tour landing page. There's nothing on there at the moment, there's no details, but if you want us to keep you in the loop about that, just contact us, say that you want to receive details about the Law on Tour, and we'll get you on our list. But for the meantime, let me say thank you for joining me this morning. It's been a pleasure. Have a good day, and I'll see you sometime for the next briefing, or maybe even for the Law on Tour. But for now, goodbye, and thank you very much.